Okay. Hi, everybody. Good night, honey. Say goodbye. You know, the kids, we yell up good night like 10 times. Let's see who's here. I've got to get to the live chat. Let me just do that and make sure I'm in the right chat. Live chat. Is this it? Yeah. All right. Top chat. Go to live chat. Is this in front of my? I don't understand. Like, it seems like every time I'm turning around. Whoa! Every time I'm turning around, someone's changing my thing. Now my camera's all. It looks different. Maybe it's my stream live chat. Let me just do that. That looks weird. Okay. For some reason, live chat. I'm all the way over on one, but I'm not that way when I'm looking at the actual thing. Okay, I'm not going to worry about it. It's my. I'll have to fix it in Streamlabs, and I'd have to shut it down. Anyway, we're going to be looking at other stuff. I went through this. Every time I'm turning around. And hold on a minute. Now you're giving a looping sound because this is playing. Sorry for the echo. So anyway, I went through like a lot of the stuff that's been going on. One of you asked me like, what's going on with the Maya case, and I was like, what's going on? But there's a lot going on with it. A lot. John Hopkins defense team has filed a motion for a new trial because of juror misconduct. And the juror misconduct is with juror number 1, who we talked about before, right? My back is driving me crazy. Okay. And the reason being is that they mention other YouTubers, they mention lawtubers, they mention laytubers. Well, that's my term, meaning just regular YouTubers that were at the trial, YouTubers that weren't at the trial, yada, 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 yada. And here's what it boils down to, is that we're going to go through the motion, but there's a lot of posts, a lot of comments that were posted that this hippo, I think it's hippo lover, hippo something, was going on different YouTubers that were talking about Maya and talking about them, and then you got that's the wife of juror number 1 allegedly, and apparently I guess the thought is that she was in the courtroom and they didn't let anyone know that was juror number 1's wife that was there. Like a lot of crap. So we're going to take a look. Let me see. I have the PDF here of the motion. I'm going to pull it up. Is this? Where's my motion? My motion. My motion. See if this is it. Is that Maya? No. Maya, here we are. Okay. Let me pull this over. All right. Let me just get so I can see your chat while I'm doing this in case you say anything. Okay, so let's go. Hi, Julie W. Hello, Kevin Leonard. Hi, Margot. Hi, Chris Eliza Ward, Linda, Sherry. Anybody I forgot? Okay, so let me make this a little bit bigger. Okay, this was filed on 11/24, and it's in the Circuit Court of the 12th Judicial Circuit in and for Sarasota County, Florida, Civil Division. Jack Kowalski, individually, Jack Kowalski as parent of next friend of Maya, a minor, and Jack Kowalski as personal representative of the state of Beata Kowalski. Plaintiffs versus John Hopkins All Children's Hospital. Okay. Defendant John Hopkins All Children's Hospital, pursuant to Florida Rule of Civil Procedure, blah, 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 timely moves this court to grant 1. Renewed motions for directed verdict, and if those motions are denied, motions for new trial, and if those motions are denied, motions for remitter as to each of the 3 plaintiffs as to each of the claims submitted to the jury on the verdict returned on Thursday, November 9th of 2023. The defendant also moves this court to grant the same motions concerning each of the claims for punitive damages for the 3 subclaims for false imprisonment and the 1 subclaim of battery, for which the jury returned the bifurcated verdict later in the day on November 9th, 2023, awarding a total of $50 million to Maya Kowalski as punitive damages. This motion is unavoidably lengthy, but in the end, this court has little choice but to direct a verdict on all claims for which this defendant should have received that relief earlier, and to grant a new trial on both liability and damages for any remaining claims. The jury voted yes on every possible method to award compensatory or punitive damages against John Hopkins All Children's Hospital. Under the leadership of juror number 1, the jury voted yes, despite the fact that under the law instructed by the court and the evidence presented during the trial, many of the claims were not proven, or, at a minimum, the manifest weight of the evidence was contrary to a yes vote on those claims. The court allowed plaintiff's counsel to use an improper method of closing argument that was intentionally designed to mislead the jury about both the method to decide damages and the reasonable range in which the jury was free to operate. In the improper closing argument, plaintiff's counsel requested aggregate damages of $201,573,728. The jury awarded $211,451,174, approximately 105% of that request. Both the awards for the personal injury claims of Maya K. and for the wrongful death of Beata K. are many times higher than the range currently awarded by other juries and recognized in case law for such awards. Under the leadership of juror number 1, the jury's verdict was obviously tainted by the improper closing argument of plaintiff's counsel, but it sometimes awarded amounts even higher than plaintiff's counsel requested. It is patent that the jury did not award non-economic damages as if those claims had been tried separately, and the same is true for economic damages for which duplication of award is rampant in the verdict. This court, before that closing, committed to the following: the law after the return of the verdict, if plaintiff's argument resulted in such a massive, tainted verdict. The awards are so arbitrary that they cannot even be used as a reliable measure for remiture. A remitter in this case would simply require the court to serve as a fact-finding jury of 1. This court must grant a new trial as to liability and damages on any claim for which a directed verdict is not granted. After the jury returned its verdict determining liability, compensatory damages, and making findings on the substantive issues allowing for an award of punitive damages under Section 768.72 Florida statutes, That court proceeded immediately with an abbreviated trial on the amount of punitive damages, in part because this case needed to be completed on November 9th for the reasons asserted by the court. The plaintiff proposed a verdict form for the first time that included a claim under Section 768.731C that the punitive damages should be unlimited because the defendant had a specific intent to harm Maya. Not only is there no evidence that would establish that claim, but the claim is very clearly a substantive claim involving the entitlement for damages in excess of those normally allowed under the section of Florida statutes. As a matter of basic due process, the claim under that statute section needed to be pleaded in the Eighth Amendment complaint by something more than a conclusory claim that the defendant had acted willfully, wantonly, or maliciously. The defendant needed to have the opportunity to present evidence on that claim prior to the initial verdict in this bifurcated trial to move for directed verdict on the claim at the close of the plaintiff's case and to argue this matter in its main closing. Instead, the court placed this substantive issue affecting the cap on punitive damage on the jury's verdict for the second phase of the proceeding. But okay, there's a lot of pages in here, so we're not going to go word for word in here, but let's see. The jury, they're talking about how they rushed that second phase of the trial through that day because the trial needed to end that day, and that they say that the plaintiff's closing was done in such a way as to mislead the jury about the awards. The jury awarded another $25,000 for a combined false imprisonment and battery, where she was placed on a bed, either in her own hospital room or some other hospital room, for a matter of minutes on January 6th of 2017, which is the day she went to the courthouse. This is the day her mother wrote her suicide note, unaware of this incident. Maya was held on a hospital bed to document the condition of her skin photographically prior to leaving the hospital. She had on her shorts and a bra for these photographs, which were not shared or publicized at all by the defendant. It should be noted that the defendant maintained that she was actually photographed again on her return, but in light of Maya's insistence that it occurred once, the verdict is only for a single event. Maya saw both her uncle and her psychologist, Dr. Duncan, on that same day. She seemed essentially normal to her uncle on that day, and she made no complaint to Dr. Duncan. The jury determined this conduct was more than an intentional tort. It decided that it was an intentional misconduct under the definition in Section 768.72 Florida statutes and awarded an amount of punitive damages that would be excessive even an Engle wrongful death case where a plaintiff suffers for years with breathing disorders allegedly brought on by addition to cigarettes caused by a fraudulent conduct of a large for-profit international corporation. The motion is filed within the mandatory 15-day window that is provided for all cases without regard to the complexity of trial length. Okay, I just want to do one thing. I want to grab something because I'm going to not just go completely on this. I want to bring in some other stuff that was from the trial. Okay, so let me just grab my other stuff here. Hang on. Right over here. I want to show you some stuff because I know this can get too much. I want to show you some of the exhibits from the trial. And I think maybe some of you didn't watch the trial. You might have missed it. Some of you watched the trial. Maybe you're like me. You just it got to be just freaking too much. Hang on. Oh, what's going on? Why do I see what's going on? Okay. Oh, shoot. on a second. Okay, while that is spinning, I can at least read whatever this one is. Let's see here. The motion is filed within the mandatory 15-day window that is provided for all cases without regard to their complexity or trial length. Okay, finally opened up. Okay, as soon as I started reading it, let me see. The thing I need, the thing I need. Okay. Oh my gosh, what is wrong with this? Oh, here, I can do it here. Thank you. There we go. Okay. Now, let me go over here. And I'm going to get some of the stuff here. Okay. Okay, so here is some of Beata's journal defense exhibits. Okay, these are some of the defense exhibits I'm going to show you. This is Defense Exhibit 3239 that I'm going to pull up. Okay. There we go. Get over there. 10:25:16, 11 a.m. Millie. This is Beata's journal, okay? Manager at Dr. Barr will speak with Dr. Barr, Ashley, nurse practitioner, regarding treating for Maya / us. Redo. Need records to be. I think that's something to John W. And then 10:25. Able to, let's see here, testify 15/16/70 November. Here 10:25. Looks like POV Deborah. Court dates 11/8 and 11/20, 11/8, 10 to 5, 11/10, 9 to 5. Hannah, Dr. Hannah, 11:10, 3 p.m., 1.5 to 2 hours. This one, 11/8, Kirkpatrick, that's Kirkpatrick, I'm sorry. Kirkpatrick, 11/8, it's look like she had a space here. She does 2 hours. Duncan, And then Cantu, Spiegel, Barr, Becky, Eagle Wings, PT, physical therapy, I guess, agility, Dalton, Jessica, some Sandy Ryan, Carol Tapp. Hold on. Get the next one, which will be Why is that so little? Why is that so little? There we go. Joy Sacco, State of May. We'll try to see Maya tomorrow. Sent by Father Jack and Sister Francis. We'll see Maya 10:25 with Linda. Alleluia. 10:25, 2016. Joy Sacco, Linda Brown with Mother Mary. Made it to Maya's room. Mother Mary opened the door to unit for them, and they went straight to Maya's room. Amen. Then they, Joy and Linda, went to chapel, prayed for Maya and us times 2 hours to get Maya united with her family. Other people joined in prayer as well. Thank the Lord for this blessing. Okay. And that was Defense Exhibit 3239-0021. Okay, hang on. Let me get the next one. Okay. This one is Defense Exhibit 3239-0020, 1022-904, Nurse Kim, phones taken away, do up well with child life. Let me see what that says, if I can see it any better on this side here. We'll check with child life, it looks like. Deborah, attorney notified, violations of patient's rights. She's saying this, she had her phone taken away. And then this says the nurse EB tests were never done and never ordered. I asked Kim, what about test? I knew 2 were for blood. I asked about 3 samples. She stated that it doesn't appear it was ever collected. 10:23, message sent, Mary Ann St. Clair, RSD parent Yahoo group. Okay. Okay, oh, let's get over here with this, please. Can priest visit Maya or Sister Francis? Ask neighbors to do video testimony. What Kim of parents we are, of what kind of parents we are, what we did for Maya, day and night, QD, on a QD basis, day and night. Can Dr. Hannah visit Maya? Deborah S. advised us to have family members keep wow, she writes so horribly. Keep collecting or something. Social worker Kathy Beatty. Visitations from family and friends. If no answer or denial, then call Pat Cazzetto and they CPS, and that's exhibit number 3239-0016. Okay, next one. This is Polish Embassy. Email, text, re-testify. Hannah, Kirkpatrick, John W. Let's see, Cantu, Kirkpatrick, Hannah. She has people listed here. Okay. Find out schedule to testify for Kirkpatrick. And it says out till 10:27, Hannah, and then she lists them again, and she puts a question mark. Friday, 10:28. Okay. This one says 10/20/16, Thursday, 5:38. TX text, and then it says 7N, number 709, 5:38 p.m. Jenny in parentheses, Jack. Maybe it Jack's up here, or is that? Left a message for nurse to call back. She has a number here. Lindsay. Denied going. Update on Maya's condition. Asked. Who found a mouse on 10/8? Wow, she writes horrendous. RN stated, I don't believe it. Tylenol doesn't work for Maya's pain, only damages her liver. Exclamation point. Report from Kinsley RN, spirits good, patient, pain 9 to 10, burning 100%, eating 265, 26.5, fighting for, I don't know what that picture is there. Let's see here. I'm going to go through some of these and not, let's see if this one, Maya's liver, no, Maya's IG was due 10/16/17 per Dr. Barr. Let's see here. She's still talking about stuff, nothing that's... CPT. Oh, here, let me take this. Let me put this over here. This one I'm going to do. Okay. So this one says 10/13/16, 5:41 p.m. Call from CPS. Maya taken away. 35 minutes on phone with CPS. The worst day of my life. DSF, she has written here. 10/14/2016, Friday 9:30 or court hearing. DCFS will not follow procedure. Didn't contact Dr. Hannah or the other doctor. Everything I owe. Hold on, let me see what this says. Everything I owe, something that she wrote on that dark paper, it's hard to see. Retaliation from Dr. Halleck. She's saying this is retaliation. Should be in jail for destroying families, for destroying good families. Sally Smith should be in jail for destroying good families. That's what she says there. Okay. This one, get over there. Torture chamber, inhumane, unethical, not eating. Occupational therapy was crossed out. Only small amounts of something. Risk management. Called Louise Behrens. Spoke with social worker Kathy Beatty, 10/11/16, NP. Off, let's say, Ativan. She's got medications here. Per Dr. Elliott. Let's see. All right. Okay, this one's on the side. It says risk management. Called 1010. Called out care. Call out care in ICU. Dr. Rose. Monday, 10:10, Dr. Rose, 10:08, Saturday, spoke with Hannah, Dr. N. Patel, 10:08, Saturday, anesthesia, ICU, ATT, something, Dr. Halleck, strange overnight. Let's say, I don't know. It's crazy. Reported to CPS over Dr. Vos. Called CPS. I told her I wanted Maya. To Dr. Hannah. Okay. Michelle Smith, okay. Dr. Bingham, 1013. Never met Dr. Elliott. Melendez. Or anesthesia again. Jenny. Dr. Dolan, okay. Dr. Patel. Nicole Patel. Dr. Elliott. Turned to ass. Okay. See what this one is. Here she put just medications. Let's see what else. I'm just because I'm trying to go through somebody to see what's okay. All right, that's not that. But there was. Let's see what's going on here. Okay, so she used a notebook. It was a composition book with Kyle's name on it for this journal. Let's see. She listed the organization Stop Childhood Pain in her journal. And next to the entry, she wrote no because they do not support ketamine comas for children. So she put that in there. And then if you go to the site that she put in there, which is this one, and then she put no, and that was because here it says ketamine is an anesthetic agent related to PCP, angel dust. Because of this, it has the tendency to produce hallucinations and paranoid delusions. It has been studied in adults with CRPS, and over 12 weeks, there was a reduction in pain that was most notable the first week of therapy, but there was no difference between ketamine and placebo at the end of the study. Even with the reduction in pain, there was no improvement in function. In a study of oral muscoketamine in 12 children with chronic pain, it seemed effective in 5, but did not last longer than 12 months. And in one child who had amplified musculoskeletal, I can't even speak tonight. Musculoskeletal pain in this study, it was not helpful. Ketamine comas are not approved in the United States and are very controversial and have not been proven to have any lasting benefit. Ketamine comas have been associated with paralysis, pneumonia, and pulmonary embolism, which can be life-threatening. There is increasing recognition of liver toxicity as well as prolonged mania. We had one patient who years later was still suffering hallucinogenic flashbacks after having ketamine infusions. We saw another patient who did well initially after a ketamine coma in Germany, but after a 40 booster ketamine injection, she had severe pain in her feet that she could not even touch them to the floor. Both of these patients did well in an intense physical and occupational therapy program, and that's what we talked about from the get-go. We said that the exercise, the occupational physical therapy was the thing that worked for all of them. And you hear them themselves talk about how Maya got up to work out. That's what helped her. She wasn't on ketamine then because her mother was gone. She hadn't been on ketamine, so she was getting up, showed what the exercise was. Ketamine comas are not approved in the United States. They're very controversial. There is increasing recognition of liver toxicity as well as prolonged mania. She was worried about liver toxicity. She's worried about Tylenol. You're worried about Tylenol? What about ketamine? We have one patient who years later was still suffering hallucinogenic flashbacks after having ketamine infusions. We saw another patient who did well initially after a ketamine coma in Germany, but after 40 booster ketamine injections, she had such severe pain in her feet that she could not even touch them to the floor. Both of these patients did well in an intense physical and occupational therapy program. Possible side effects of ketamine include death, hallucinations, I can't speak tonight, prolonged mania, paranoia, psychotic symptoms, liver toxicity, addiction, drug abuse, heart problems, arrhythmia, breathing difficulties, rigid muscles, extreme pain, and nausea and vomiting. Okay. Let's see. Back on this. I don't want to go through something else. Okay, so let's see. 1-3-17, Andra Day Rise Up, YouTuber, what'd you say here? Something, Cleveland, Cope Canaveral, what's she saying here in this one? Okay, I know there was something else I want to show you. Let's see here. There was, what did Jack's own notes? Okay, so Jack had notes. Let's see. Before Maya was released to be evaluated by Dr. Duncan at the courthouse, Catherine Beatty instructed Maya to remove her clothing with the exception of her underwear and bra. She took photos of her prior to leaving the hospital. Maya was extremely uncomfortable and felt violated from this incident. She was told by Catherine if she did not do what she requested, she would not be able to go to court. Upon her return to ACH, Catherine instructed her to remove her clothing to take photos again. Okay, so let's see. We're going to go in here because the defense is supposed to wipe the floor with Dr. Chopra, right? So let's see what's going on here. Okay, let's go back to our thingamajigger. Where is our PDF? There it is. Okay, let's keep going here. Let's go to table of contents. Let's see. Renewed motion for directed verdict, motion for new trial on errors occurring during the trial. Let's look at page 17 and see what the errors were, okay? Page A motion for a new trial based on legal errors occurring during the trial is analyzed separately from a motion based on the manifest weight of the evidence. A new trial is required where the trial judge becomes aware of a specific prejudicial legal error, or when he or she finds that the jury's verdict is contrary to the manifest weight of the evidence. Excessive motion for a new trial that's based on excessive awards and damages. A trial court may order a new trial on the ground that the verdict is excessive. A motion for remittiture of compensatory awards or damages. Renewed motion for directed verdict on claims for punitive damages. I want to get to the point where it says excessive awards. Issues affecting all claims. Prior to trial, this court granted a summary judgment determining that the defendant had statutory immunity under Section 39.203 Florida statutes for reporting the claim to DCF for the investigation of that claim, and DCF's decision to pursue a dependency proceeding against Beata and Jack. In exchange for obeying this statute and for cooperating in good faith with both the dependency court and DCF, the defendant was entitled to immunity for any act authorized or required by Chapter 39. Those acts included keeping Maya in the defendant's hospital even after she was ready for discharge in October. Those acts included waiting for a transfer order to a facility that was better equipped and staffed to provide the therapies that Maya needed. That order never arrived. The defendant could not transfer Maya to a hospital that provided ketamine infusions because none were known to exist, and the dependency court did not enter any order authorizing that treatment. The immunity should have extended to complying in good faith with the multiple orders entered by dependency court regarding visitation and communications, but this court interpreted the protection given to the hospital very narrowly and allowed negligence claims as well as intentional torts to be litigated for actions for which the defendant was entitled to immunity. To be clear, the defendant is not maintaining that statutory immunity would give it a free pass to torture a child or place a child in a dungeon, but acts like placing Maya Kowalski in an ordinary hospital room to be video recorded to confirm whether her actions are consistent with CRPS or are instead consistent with psychological problems that may have been caused or enhanced by her mother's behavior should be acts for which the defendant has immunity. So too should the act of keeping the child in the hospital when the defendant expects that the dependency proceeding based on the investigation commenced by its hotline report will be filed imminently. So what they're saying is that the hospital should have immunity because they gave this to, Child Protective Services. And Child Protective Services are the one that said, this is what should be done. It was done in the defendant's hospital, but they're saying that they should have immunity for this. Photographs taken to document her skin condition before she left the court where her skin could be affected should be immune. The defendant is not claiming that a typical malpractice claim for a treatment in a hospital should be exempt, but after the entry of the shelter order, the parent's right to make medical decisions did not extend to demanding ketamine infusions for their daughter at the hospital when the prior infusions were a major component of the reason the DCF filed its proceeding. The Kowalskis and their attorney could have filed an emergency petition to try to convince the dependency court that it should authorize such treatments, and then the child could have been transported to Dr. Hanna's office for that treatment. But they did not, and there is little reason to believe that a judge considering evidence that would have established that the standard treatment for CRPS in hospitals across America did not include high-dosage ketamine infusions would have granted that motion. A judge learning that this process was only being performed by a limited group of physicians, more as a matter of experimentation than as a treatment modality acceptable and appropriate by reasonably prudent similar healthcare providers. So they're saying we couldn't bring her to any facility that did these ketamine infusions. There are none. And this was more experimental than anything else, and thus the medical negligence claim in this specific case is a claim for which the defendant should have immunity because any ultimate decision to reintroduce the treatment following the shelter order was a matter for the dependency court. The claims for intentional infliction of emotional distress would not be claims for which the defendant would be entitled to immunity if proven. The problem in this case is that conduct interrelated with or heavily affected by the rules and regulations imposed by the dependency court and DCR was often used to confuse the jury and to allow the admission of evidence that was not extreme and outrageous conduct intolerable in a civilized community. On September 8, 2023, just before trial, the plaintiffs filed a motion in limine to exclude any mention of the DCF Chapter 39 and the dependency proceeding at trial. The court denied that motion but took the position that it would only allow very limited reference to those proceedings. The defendant recognizes and agrees that litigation immunity prevented use of testimony from that case as evidence against a party to prove liability, and likewise agrees the court had discretion to limit extensive discussion of legal arguments and rulings in that case. But the fact that the proceeding existed and had a major impact upon the stress in the family, and that the Kowalskis attended multiple hearings that upset them, and the full explanation of the hearing that triggered Beata's suicide became off limits after motion in limine was heard. This court, under the urging of the plaintiffs, transformed a statute giving the defendant a shield of immunity into a sword that was repeatedly used by plaintiffs' counsel. Objection Chapter 39 was used to prevent the jury hearing relevant and necessary testimony and evidence, including, for example, the December report of Dr. Sally Smith. The defendant believes the transcript will show instances where the court limited evidence based on Chapter 39 on its own motion. The court repeatedly told the jury that the defendant was not responsible for Maya's long stay in the hospital, but the plaintiffs repeatedly presented witnesses or made statements in front of the jury about the child being trapped in the hospital. Maya, both in court and on the telephone recordings with her mother, was explaining how desperately she wanted to go home to her mother. The jury clearly did not understand the nuances of immunity under the instructions given by the court. The limitations placed on this issue made it impossible for the defendant to keep the jury from being enraged about events and circumstances over which the defendant had no control or legal responsibility. This is most evident in the three claims for intentional infliction of emotional distress, but it also impacted the claims for false imprisonment and battery. Given the size of the monetary awards, it appears to have affected all the claims. Hold on a minute. Put something about. I need my lip balm. The defendant submits that this court erred in the failing to grant broader immunity to this defendant and in failing to permit a fuller explanation from the witnesses, including the DCF witnesses about that lawsuit and its impact on the family. This error warrants a new trial at a minimum. This error does not impact this one case alone, especially in a case where a hospital has recognized even before the entry of a shelter order that a child needs specialized rehabilitation better available at other hospitals and that the child is ready for transfer. It's cooperation with a dependency court that never enters an order allowing it to transfer the child to a hospital with a specialized inpatient or outpatient program during the following 3 months should not subject it to the risk of a judgment. It certainly should not risk the possibility of the huge judgment the jury's verdict would require in this case. Okay, so let's see. The court erred in allowing the plaintiff's attorney to make the massive request for damages generated by the per hour, per component closing argument, which affected every claim in this case. So they say that by dividing the damages into hourly amounts for components of the overall award of non-economic damage and employing a period of 8 hours or longer for each day of a plaintiff's lifetime, this method can make an award exponentially higher than is appropriate. And in this case, the plaintiff's counsel used 12 to 14 hours per day at rates of $100 an hour to present with a straight face aggregate damages many times higher than the amount a reasonable jury would normally award. For Maya Kowalowski's claim in the aggregate, the plaintiff's counsel divided non-economic damages into past and future claims for pain and suffering, and for mental anguish, and for loss of the capacity to enjoy life. These separate claims were then given an hourly value of $100 per hour, which resulted in a daily total damage, undisclosed to the jury, of $8,400 per day for a lifespan of 70.42 years. The aggregate amount requested by plaintiff's counsel resulted in amounts spread among the various claims for her that totaled $64,496,000 just for non-economic damages. Without considering income on that amount, that award would pay $915,875 per year, or more than $2,500 per day for every day from the time of this event until she dies. Even more shocking, given Mr. Kowalowski's life expectancy, plaintiff counsel recommended $2,700 per day for Mr. Kowalowski for a total of $26,640,862, but the jury gave him $50 million. That is more than $5,200 per day, and it too is awarded in a lump sum that will produce extensive income over his lifetime. Within about an hour of the commencement of deliberations, despite the fact that the jury needed to review an immense collection of exhibits introduced into evidence, but not shown by either party during the trial, under the leadership of juror number 1, the jury was already asking the court to provide the documents and testimony that was used to support the huge aggregate award. Unfortunately, the jury followed the argument of plaintiff's counsel instead of the law, and entered yes for every liability box and awarded damage amounts that are patently excessive and irrational when examined claim by claim. The award for Mr. Kowalowski for past medical bills totals $1,513,498, which clearly demonstrated that the jury duplicated damages. The award of $5 million for insurance fraud, when plaintiff's counsel suggested $1 and has even given this court a proposed judgment for only $1, demonstrates the jury was totally lost in passion and prejudice when considering the issues in this case. Simply put, this method was an artifice that misled the jury. A jury influenced by prejudice and passion has produced a verdict so unreliable that a new trial is needed on all issues. The decision to grant the defendant's motion for directed verdict on the negligent training claim only at the very end of this trial allowed the jury to be confused and misled by irrelevant evidence that impacted many of the claims in this case. The grant of additional time to the plaintiffs in this case severely prejudiced the defendant. Let's see. After the defendant had carefully used limited time on cross-examination in the plaintiff's case in order to have sufficient time for its own case, This court granted the plaintiff additional time for its case on not one but two occasions, coupled with the inefficient manner in which the plaintiff's counsel introduced exhibits and the testimony of witnesses. These extensions placed the court behind on its timeline that required this case to end on November 9th, 2023. In the end, the defendant had many hours of time remaining, theoretically, when it rested. The defendant knew it had time, but no remaining days to present more witnesses or, for example, to present several hours of the video from the room on the 7th floor that contained the video and EEG equipment. In retrospect, given that it is clear that the jury did not review exhibits such as the EEG video clips, additional testimony would have been very important to preventing the runaway verdict on compensatory damages and punitive damages. But it also would have forced a mistrial because it would have caused the jury to have no time to deliberate by taking professional steps to fit this trial into the timeline required by the court, but skewed by the extra time given to the plaintiff. The defendant received an irrational verdict from the jury. It was then compelled to try both the substantive component and the usual damages component on the bifurcated punitive judgments claim, in an abbreviated mini-hearing that resulted in a $50 million award of the punitive damages and finding on specific intent that are unstoppable under either of the two optional burdens of proof this court gave to the jury. Okay, and then we've got Dr. Eli's testimony over objection. Some occasions, Dr. Eli Neuberger's depositions are the worst example. This court allowed testimony to be presented to the jury that should have been excluded. The testimony included evidence that was extremely prejudicial. His trial testimony has been transcribed and will be filed with this motion. It is cited in this motion as T. Dr. Neuberger is an elderly physician. He graduated from medical school in 1966 and gained his first experience in the Vietnam War. He is a general pediatrician who is clearly qualified to testify about child abuse issues. When younger, he taught at Harvard Medical School and served on the staff of Boston Children's Hospital, but he retired at the end of 1999 and never had an actual pediatric practice. He no longer examines more than one child a month, and the last child he actually treated was his own grandchild. He is licensed in Florida only for purposes of serving as a criminal prosecution expert. He is not board certified in this subspecialty of child abuse, but he was grandfathered into the society. Since 1999, his consultations in child abuse pediatrics have been his sustaining source of income. To be clear, the defendant does not question Dr. Neuberger's qualifications to express opinions despite his age and limited recent experience. He would have been well qualified to testify for Beata had she chosen not to commit suicide and instead have gone to trial in February of 2017 in the dependency court. But the standard of care issues in this case concerning the health care providers at Johns Hopkins All Children's are not and never have been child abuse issues of child abuse. After the plaintiff withdrew any claim concerning Munchausen's by proxy, the subject of child abuse had little or no relevance in this case. But Dr. Neuberger was allowed to become a jack-of-all-trades expert who opined on the unlawful acts and conspiracy of the doctors at Johns Hopkins All Children's, a conspiracy headed up by Dr. Sally Smith. He reached the professional opinions by reading depositions and records from the hospital. He was the equivalent of an expert juror on a criminal proceeding against the hospital staff. And this court let this testimony into evidence over objection. For example, this court admitted the following testimony into evidence at page 93 of this transcript. The portion of the first sentence in italics is the only portion of this testimony from the deposition that this court decided to exclude. It is in the deposition, but not the trial transcript. The evidence of multiple references to team decisions and abdicating personal responsibility and defer in virtually all principal diagnostic medical judgments and decisions to Sally Smith was an intentional act which was both wanton and malicious. In addition to this opinion, with regard to team decisions, I intend to opine that this so-called team represented a group of individuals who together agreed to commit an unlawful act and to harm other individuals. The witness's intention to opine was fulfilled when the court admitted this testimony. The court allowed Dr. Neuberger to describe the medical team, including Dr. Sally Smith, as conspirators, acting on the basis of a flimsy notion, performing acts preposterously conceived and cruelly executed. Okay, let's go. Maya Kozlowski's testimony was that her memories of this period were limited. She did not like the clock in her room, and one nurse apparently did a transfer from one bed to another that was rough. She may have been dropped in this move, but there is no evidence of any injury requiring treatment. Indeed, there is no evidence that she sustained any physical injury from this imprisonment. There may be evidence of claimed medical negligence during this period due to the unwillingness of the doctors to accept the diagnosis of CRPS as definitive and to begin treatment with a ketamine infusion at a very high dosage. The doctors had no knowledge that ever had been given to any patient, but this is not part of the intentional tort of false imprisonment and his claim for which the defendant should have Chapter 39 immunity as explained earlier. The defendant did not move for a directed verdict at the end of the plaintiff's case because the only evidence on this claim was provided by Mr. Kozlowski and to a limited extent by Maya. Because false imprisonment requires a plaintiff to establish that imprisonment is unwarranted and unreasonable, those factors could be at least inferred from Mr. Kozlowski's testimony. But during the defendant's case, evidence, including an email from Beata, established that at the time of the email, she was not demanding that her daughter be returned to her to take her home. The child's condition and the medical history obtained by the hospital was established in the defense case, although these matters were not an affirmative decision. It is the defendant's position that at the end of the case, it was entitled to a directed verdict because, even assuming that the Kozlowskis were demanding to take their daughter home at that time, Maya was in no condition to leave the hospital, and the Kozlowskis had no arrangements to transfer her to another facility. The plaintiff did not establish that the defendant's decision to decline her release to allow her to go home was either unreasonable or unwarranted, given the condition of Maya at the time, as well as the mindset of her mother. It would have been unreasonable and unwarranted to send a child home under those conditions. While not raised with the jury due to its complexity, the defendant also had immunity under Chapter 39 for at least 24 hours of this period and should have had immunity for the claim from the point it made the hotline call. Thus, under the standard for the directed verdict, the defendant was entitled to a what will the evidence have been presented? There was no question of fact to present to a jury on whether keeping this child in the emergency room or in the pediatric intensive care unit was unreasonable or unwanted when the parents had no plan except to take her home, where her mother could have infused her with anything. Even if the defendant is not entitled to a renewed directed verdict, the jury's verdict is clearly against the manifest weight of the evidence. The jury was deceived as to the force and credibility of the evidence or was influenced by improper matters. The plaintiffs argued that the doctors did this because Beata knew that, because Beata Kowalski was strong-willed, and the doctors wanted to harm or spite her by keeping her daughter. The conspiracy theory is simply a fantasy, unsupported by any rational evidence. The court, in reviewing for manifest weight, is allowed to consider the credibility of the witness and the strength of the evidence. And they're saying a motion for a new trial based on excessive compensatory damages. Motion on excess compensatory damages. Based on the punitive damages. The claim for false imprisonment from October 18th to the 20th. They're saying that this is the false imprisonment. She was in that room. She was recorded without her knowledge. It was done as a test to see if she would engage in activities that were consistent or inconsistent with CRPS when she was not aware that anyone was watching. Dr. Sally Smith also wanted this testing done for the DCF proceeding, although it ultimately played no role in that proceeding. The process was not actually treatment of Maya. It was primarily a non-invasive diagnostic test. If Maya engaged in actions completely inconsistent with CRPS, then the diagnosis could be rejected or at least highly questioned. If she did not, then CRPS would still be a possible diagnosis. The doctors did not obtain a separate and specific consent of the parents to move their child to this room for the test, although a consent to photograph was obtained at admission. Well, let me see something. I want to see where you guys are because I can't. There you are. Hi, everybody. Okay, hang on. 2 minutes. Let me see. Do I still have copy? Okay. But this child was rolled down the hall to this room just as she had been moved occasionally to other rooms. She claimed at trial that she was imprisoned, but in the video recording she shows no signs of thinking she was imprisoned. The child probably wanted to go home every day. She was in the hospital, but that was a decision for the dependency court, not the defendant. The jury clearly did not review the video that's in evidence. The defendant files a brief index of locations on that videotape that show the child doing normal things that she did in any other room, leaving the room, sleeping, doing crafts. The activities on this video are a little different than her activities on any other day in the hospital. Hi, Gia. How are you? Welcome. Then there's a renewed motion for directed verdict and motion for a new trial based on a verdict against the manifest weight of the evidence. So they're saying like that verdict goes against the weight of the evidence. It's not, it's not in sync with it at all, is what they're claiming. Because they're talking about similar to the claim false imprisonment the first week of the hospital. It's the defendant's position that it was entitled to a directed verdict at the end of the plaintiff's case. And now because the videotape is conclusive evidence that Maya was not falsely imprisoned or that she even thought she was falsely imprisoned at the time. This is not a claim for invasion of privacy using videotape to help in diagnosis is not a false imprisonment at all. It could have been done in a previous room if it had a camera. This is not a claim for invasion of privacy. By use of the video equipment, the recording was given to the parents' attorney within a month and was never shown publicly by the defendant. Only the plaintiff publicized parts of the video to the public. This court had ruled that the defendant has no immunity for performing this test, which had relevance to the DCF proceeding as well as to her diagnosis. But immunity aside, there simply was no disrupted question of fact to present to a jury as to whether moving this child to another room on the 7th floor for 2 days constituted false imprisonment. Even if the defendant is not entitled to a renewed directed verdict, the jury's verdict is clearly against the manifest weight of the evidence. Both the defendant's employees and the videotape itself very clearly provide more than manifest weight of evidence that no imprisonment occurred. Okay, here's the excessive compensatory damages, and I just want to get to where they start talking about the YouTubers. Motion for a new trial due to the verdict against the manifest weight of the evidence and due to excessive compensatory damages. Let's get to the juror misconduct, okay? Let's look at this. Intentional infliction of emotional distress. In court, 21C, Maya claimed that the defendant's employees engaged in extreme and outrageous conduct with either the intent to cause her to suffer from severe emotional distress or with reckless disregard of the high probability of causing such severe stress. The defendant would ask this court to read the allegations in paragraphs 239 and to 244 to compare the claim as alleged to the claim as presented in the evidence. The allegations are more or less highly exaggerated versions of the claims for false imprisonment and battery. Count 21C claims the defendant put her in a darkened room to torment the child when the evidence from the plaintiff's own expert is that sensitivity to light is on the Budapest criteria of symptoms suggesting that a person may suffer from CRPS. It claims that Maya soiled herself in this room, in a room with constant video monitoring that shows no such event, and no such video was shown to the jury by the plaintiff. It claims the hospital placed a commode out of reach as a torture technique when the undisputed evidence established that she needed help reaching a toilet in any of the hospital rooms. One of the only videos the plaintiffs actually showed to the jury involved a nurse helping her go to the bathroom. The complaint alleges that the hospital isolated her from her family and friends when the evidence and this court's own jury instructions explained the severe limitations placed on visitation by the dependency court. It alleges that the hospital did not provide appropriate medical treatment, which is a claim for medical negligence, not a claim for extreme and outrageous conduct. This is not even a claim for punitive damages associated with the medical negligence. As the defendant has tried to explain in earlier filings addressing the similar claims of the estate, this is not a typical claim for intentional infliction in which one very outrageous act is the centerpiece of the claim. So they say it was prejudice, blah, 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 blah. YouTubers, yeah. Yes, they were. We're going to get to that, guys. We're going to get to that. Yeah. Hang on. Okay, a motion for a new trial based on prejudicial legal errors. They're talking about the legal errors. And let's see, motion for, again, excessive compensatory damages. Oh, here, let's read this about Dr. Chopra, okay? So the defendant recognizes that the plaintiff did present expert testimony. The following experts supported the plaintiff's claim. Dr. Pradeep Chopra is an adult anesthesiologist with no hospital inpatient experience for over 2 decades. He opined that the hospital staff misdiagnosed the child's condition and did opine that the hospital should have used a ketamine infusion instead of the therapies provided. But Dr. Chopra has not had hospital experience in many years. The use of high-dosage ketamine in Maya's case was not only off-label, but it involved doses and infusions to a child at levels unheard of by Johns Hopkins physicians and staff. Dr. Hanna had given her increasingly higher doses in the weeks preceding this hospitalization to levels dramatically higher than those used by Dr. Cantu for the risky coma. Dr. Chopra did not suggest that the use of ketamine at these levels was common for adults, much less a small child. Nevertheless, he claimed that the hospital's physicians failed to accept the CRPS diagnosis and should have continued the ketamine infusions as the appropriate treatment. But Dr. Chopra failed to produce any evidence, as did other plaintiffs' expert that any hospital or any other institution in the U.S., much less Florida, would have been willing to continue Dr. Hanna's excessive ketamine infusion as he claimed should have been the case. At the end of this trial, there still was no evidence that any hospital would then or now have been willing to continue Dr. Hanna's ketamine infusion therapy. Either every hospital is in breach of this generally recognized standard of care as described by Dr. Chopra, or his testimony is simply incompetent. He may be able to express a pure opinion about a form of ketamine treatment for children that he himself has never performed, but that opinion in a vacuum does not establish a standard of care. Florida law requires that a claimant shall have the burden of proving by the greater weight of evidence that the alleged actions of the healthcare provider represented a breach of the prevailing professional standard of care for that healthcare provider. The prevailing professional standard of care for a given healthcare provider shall be that level of care, skill, and treatment which, in light of all relevant surrounding circumstances, is recognized as acceptable and appropriate by reasonably prudent similar healthcare providers. Dr. Chopra did not establish by himself a breach of the prevailing standard for healthcare providers. Dr. Eli Neuberger, the elderly child abuse pediatrician discussed earlier, has not practiced clinical medicine during this millennium. Some of his opinions are discussed in the global section of this motion because they affect every claim. But as a child abuse physician, much of his testimony related to Dr. Sally Smith. He stated over objection that his expert opinion was that Dr. Smith's practice with regard to this child violated the standard of care that has to do with careful and sympathetic attention to a child's presenting complaints, past medical history, and current hospital course with regard to pain, distress, ruptured family relationships, and her request for analgesic medication where Dr. Smith was with cruelty, with opacity of sympathy, with a propensity to blame not only the mother as a perpetrator, but the child as a willing and intentional cooperator, rather than to understand the child as a suffering individual supported by loving and caring persons. Dr. Neuberger's testimony was couched in obviously inflammatory and argumentative language. Okay, so Dr. Timothy Brewerton, a psychiatrist with an adult psychiatric certification, does not qualify him to testify against a pediatric psychiatrist. He testified primarily about his diagnosis that the family members currently suffer from PTSD and/or depression. He testified that Maya sustained PTSD from the events that occurred during her hospital stay, but he did not testify that it was the events caused by the defendant as contrasted with the events brought on by the dependency proceeding. He does not have the qualifications to render opinions to the diagnosis or treatment of CRPS. He could testify that a condition like CRPS could worsen the effects of PTSD, but he was not qualified to testify that anything the defendant did worsened Maya's already existing permanent condition of CRPS. Dr. John Wassenaar, the family physician, testified in sum that the pediatricians at Johns Hopkins were remiss in not calling him before considering the question of child abuse or Munchausen's by proxy. Dr. Duncan. Okay, so let's go up here. I want to get to about the okay. In this case, Beata Kowalski was not even present in the hospital after October 13th of 2016. From that point forward, only Ms. Beatty and perhaps some unidentified employee or two ever had direct contact with Beata. And this contact was by telephone or some form of computer communication. The plaintiff's theory is not that one major incident was done intentionally, but rather that a number of lesser events created the distress. Thus, the issue for this claim is an attenuated version of the same analysis presented for Maya's claim earlier in this motion, stating that within the first week, what evidence is there that some employee committed an extreme and outrageous act beyond all possible bounds of dependency, atrocious conduct, utterable, intolerable in a civilized community, and did so with the intent to cause Beata Kowalski some emotional stress, or with reckless disregard of the high probability of causing this severe stress. Perhaps the unidentified person who threatened to have the Kowalskis arrested if they removed Maya from the emergency room or the intensive care unit. Beata Kowalski's own emails admit that, at least later, she no longer wanted to remove the child in this fashion, but assuming she was always adamant that she wanted to take her daughter home and someone at the hospital actually threatened to have the parents arrested, would it be extreme and outrageous conduct for a doctor or a security guard to call the police under these circumstances? It might be questionable whether an officer arriving on the scene would decide that he or she had possible cause for arrest. But lots of people call the police to allow the police to make that decision. Beata Kowalski wanted to remove a child from an emergency room or an intensive care unit when the treating physician sent the child to the emergency room for care. She wanted to remove the child with no plan for transfer to another unit and under circumstances in which she wanted the child infused with ketamine. And she was a nurse, infusionist, whose child already had a port installed. As a matter of law, in this context, even a threat to have the parents arrested by the police is not extreme and outrageous conduct that cannot be tolerated by a civilized community. Assuming Beata was merely strong-willed and very persistent in those encounters where there is evidence that an employee of Johns Hopkins responded with extreme and outrageous conduct, was calling a doctor known to be a child abuse expert to obtain advice from her actually an act that a civilized community would not tolerate? The truth is that there is no credible evidence of any extreme and outrageous conduct by the defendant's employees in a period when Beata was allowed to enter, by law, to enter the hospital. Missing such evidence, the plaintiff has resorted to a great conspiracy based, at the very best, on speculation and the stacking of the thinnest pieces of circumstantial evidence, because the doctors were threatened or intimidated by this strong woman, and perhaps because she planned to make some complaint to someone about the treatment of their daughter, the doctors entered into a conspiracy to destroy Beata. Let's see here. Okay, let's see. Okay, so this was a motion for a new trial based on legal errors in the jury instructions and the decision to add a second theory of causation to the trial midstream. This defendant requested a series of jury instructions beginning with an instruction. That extreme and outrageous conduct must be committed with the actual intent to cause a person to take their own life. The defendant continues to believe that a common law court should not make a public policy decision on this tort that is less rigorous than this standard. The defendant will not repeat all of the instructions that it requested, but the final request was for an instruction that merely explained that a substantial factor had to be at least a 51% cause for her taking her own life. All of those options were denied. Because of the mess created by the inclusion of count 14C in this trial, the defendant requested instructions to help the jury distinguish between mere negligent acts and acts that might conceivably be extreme and outrageous conduct. But this court denied those instructions. Moreover, prior to trial, each party suggested differing instructions on the conduct sufficient to constitute a legal cause of suicide, but neither party suggested a test of substantial factor that essentially requires that the defendant conduct to be no more than a concurring cause. This court on its own decided not only that substantial factor could be sufficient instruction, but also that due to the court's uncertainty as to which approach was legally correct, that it would give the jury both options to consider on causation. Respectfully, one tort can only have one theory of causation in its elements. This court created optional elements for this tort, a tort that has never been tried before to a jury in Florida in mid-trial. It was error to do this. The plaintiff's closing argument relied heavily on substantial factor and equated uncontrollable impulse with that test. Okay, a motion for a new trial related to testimony of Dr. Richards. Okay, excessive compensatory damages. The defendant realizes that this is a long set of motions, but factually there are 10 overlapping claims, including the 3 false imprisonment claims and the 2 battery complaints and the 2 claims for intentional infliction by the estate. Including punitive damages, the verdict exceeds $260 million. These motions address a verdict for $250 million for claims that each raise serious questions about whether they even should have been submitted to the jury. They address what appears to be the first ever trial of intentional infliction of emotional distress causing someone to take their life, as it is a claim by the estate of a woman who had not been at the hospital for almost 3 months, was never a patient, and had almost exclusively indirect contact with hospital employees. They're saying that this woman, that she wasn't even at the hospital. You know, what was her contact with these people? How was this, you know, the factor here, and how did this cause all this? But a case where the taking of her life occurred after events in a court proceeding for which the state and DCF are protected by sovereign immunity. These motions have merit and they're warrant full consideration. So there was court proceedings. Department of Children and Family Services was involved. They have sovereign immunity, but what's going on, right? These motions have merit and they warrant full consideration. Okay, now, I'll tell you about, hold on one second. back and get.
I don't know.
What the heck was that? Someone's yelling. Okay, hang on. Let me go over here. Okay, 1 second here.
For this.
Okay, let me see something over here. Hold on. Okay, so let me see here. Get to it. So here's about the jurors. Okay, so I'm trying to. The motion filed in Sarasota County, the hospital attorneys claimed during the trial, juror Paul Lengiel shared information about the case with his wife, who then shared it on social media platforms. Yolanda Lengiel also attended at least one day of the trial in Venice, meaning she could have heard attorney discussions with the judge that were made outside of the jury's presence, right? And then she's going home with, obviously, her husband. In a decision that gained national and international attention, during the trial, Yolanda Lengiel frequently posted on live YouTube feeds of the trial and in a Facebook chat group, largely supportive of the Kowalskis. Screenshots from social media included in the legal filing show that Yolanda met with social media influencer known as Jules, who, the motion states, is connected to the Kowalski family. It cites as evidence a video Jules posted on her TikTok page, stating that she gave Maya her rosary beads before Maya's live testimony on October 9th. Yolanda Lengiel also posted on social media questions her husband intended to ask of witnesses and about a juror note sent with the jury when they were deliberating. Jurors were reminded multiple times every day not to talk about the case or read media coverage. The motion asked for a retrial and for interview and investigation of Lengiel to identify other possible misconduct. The evidence reveals a shocking level of involvement in the case and palpable bias in favor of plaintiffs on the part of juror number one's wife, Mrs. Lengiel, as well as social media posts sharing inside information Mrs. Lengiel could only have obtained from her husband. Nick Whitney, one of the attorneys who represented the Kowalski family, said they will be filing a response by the court's deadline on Monday at 4 p.m., which they did. Hospital attorneys have previously tried to get Lengiel removed from the jury in the final week of testimony. They filed a motion that stated his questions to witnesses showed he had made up his mind about the case before all the evidence was presented. Judge Hunter Carroll ruled against the motion, saying he saw no evidence to support it. Lengiel's jury form states that before retiring, he worked as a law enforcement officer in the city of Hialeah and has lived in Sarasota County for 11 years. Lengiel posted on social media after the trial, including a mock picture of Carroll in battle gear in front of a smoking all-children's hospital, saying, "I went and got the IJ documents myself, and apparent reference to an immediate jeopardy finding with a review of all children's that was presented as evidence during the trial. Okay, hold on. Now I've got to go get my other file here. Hang on. Where the heck is my... Hang on. Let's see. Okay. Come on. Okay. Hang on. I'm trying to get something here for you guys. Oh, there's something else. Yes. And I'll tell you while I'm looking for something. The attorney, which is in really horrible taste, the Kowalski attorney appeared on a podcast and started laughing like crazy about a witness that was being deposed, and had made fun of them for, I guess, losing control of their bowels, to put it mildly, was laughing like hysterically at this. Meanwhile, people were really put off because they're saying, oh, it's okay if Maya has issues like that. We're supposed to be like extremely sympathetic, but this is somebody, and you're laughing and you're going on podcasts now after the fact and just blasting that out there in order to what? Embarrass them or to, I don't know. It was like such poor taste, horrendous. So hold on, I'm trying to see where this thing is. Show you something, and I'm trying to get to it. There's like so much stuff though. Okay, this is what I want to get. Okay, so this is okay, this is the other filing. This is filed 11/2/2023. So this was filed before the verdict. And it says, Defendant John Hopkins, All Children's Hospital, by and through undersigned counsel, moves this court for an order disqualifying juror number 1 from serving on the jury which deliberates to decide the above-styled case. Defendant submits that juror number 1, on multiple occasions and through multiple questions and statements communicated to the court in connection with questions, has revealed a bias and prejudice in favor of the plaintiffs and against the defendant, and a violation of this court's instructions to the jury not to form or express any opinion about the case until retiring to the jury room to consider a verdict after having heard all the evidence, the closing arguments of the attorneys, and the charge of the court. Throughout this trial, of this cause, the jury duly sworn to hear this case, along with alternates selected, appear to have paid diligent attention, and their attention has been reflected in a substantial number of juror questions. In this process of posing such questions, however, one juror, identified as juror number 1 in his questions, has repeatedly revealed not only a substantial bias and prejudice in favor of the plaintiffs and against the defendant, but also a violation of this court's instructions as set forth in the Florida Standard Jury Instruction 1.1 that he or she should not form or express any opinion about the case until they have retired to the jury room to consider your verdict after having heard all the evidence, the closing arguments of the attorneys, and the charge of the court. Juror number 1's statements evidencing the above include, but are not limited to, most recently in questioning nurse Sylvia Ballweg. A witness called the defendant. The juror prefaced a question by making a statement to the effect that the witness was a breath of fresh air, or words to that effect, since she was the first person from defendant who appeared to have cared about Maya Kowalowski. In a question to defense witness Kelly Thatcher, APRN, juror number 1 asserted that his ethnic background was the same as the decedent, Beata, with the result that both the juror and the decedent tended to be pushy. Juror number 1 stated specifically that he identified with the decedent and questioned whether the witness had overreacted to the decedent, suggesting a belief that she had done so due to the decedent's ethnicity. And, ethnicity. Juror number 1 asked a question of an early witness, stating that there appears to be probable cause of improper action by or of Sally Smith in her assigned role at Johns Hopkins, thus indicating that the juror had formed and was expressing an opinion regarding the case and the experience and the evidence in violation of the court's instructions, and indicating a predilection against the defendant. Juror number 1 expressed an opinion in preface to questioning of witnesses, indicating an understanding of CRPS can come and go, get worse, recede, and disappear, but reflecting not only an opinion about certain matters in issue, but an acceptance of the plaintiff's evidence before even hearing the defendant's. Questioning various witnesses called by the defense, including Charlotte Laporte, in an adversarial manner, confronting her with questions regarding whether she can beyond doubt affirm that, or whether she was able to attest to matters she addressed in her testimony, specifically those relating to Kathy Beatty, and telephone calls, again indicating an adversarial predilection against said testimony and in favor of plaintiffs. Questioning witnesses including Ms. Tori Nihas as to whether her team or the hospital possessed certain photographic or video evidence, and by posing this question long before testimony had been concluded or argument submitted, the juror has indicated that a burden has been placed upon the defendant above and beyond any contemplated by the court. In questioning Ms. Laporte, the juror in question began a question with a representation that plaintiff had provided address for Maya to defendant or Ms. Beatty, indicating prejudgment of the evidence with respect to that issue and without having heard all of the evidence pursuant to the court's instruction. In the same question set, the juror in question confronted Miss Laporte with questions regarding whether she knew the dress in question resided in Ms. Beatty's office and or whether the witness knew it was not timely given to Maya, indicating an acceptance of plaintiff's evidence before having heard all the same, and indicating an opinion with respect thereto, both of which violate the court's instructions. Questioning at least one witness with the preface that the plaintiff, Maya, was more mature than a usual 10-year-old and handled her pain differently, thus expressing opinions that reflect acceptance of the plaintiff's evidence and testimony, and expressing opinion regarding the same, again, in violation of the court's instructions. Questioning witness Stephanie Graham in an adversarial manner regarding statistics related to the success of her case ratio and also regarding her interrogation of the plaintiff, Jack Kowalski, despite the witness's own testimony that the discussion in question with Mr. Kowalski was an interview, not an interrogation, thus indicating an adversarial attitude and bias against defendant's witness, as well as implicitly expressing an opinion or conclusion regarding the case long before the evidence had ended. Questioning witness Richard Elliott in a sarcastic and biased manner, indicating an opinion regarding the subject of his testimony, which was billing. Okay, let me go to, I'm going to get something else here. Let's see. So that was when they were talking about the jurors. That's prior to the verdict, okay? Prior. That was on the second. But they didn't remove juror number 1, and that went on for some time right there. Now, let's see what this is. Okay, so apparently, and I'm not familiar with this person, Jules. Apparently, she said she did not know Anderson, the attorney for the family, but then there are screenshots of her replying to people, allegedly her, saying, for the kids, I have made excellent contacts, not just the family, but the families of the legal team as well. And then she said to someone else, I know I spent a lot of time with Greg and all the intimate members close in this case. Just saying. And Anderson said in his last interview that he doesn't know Jules, and so does she, in a stream she made on some podcast or video. But here there are comments made that contradict that, so let me see here. Let me see. Okay, questioning witness by print. Trying to find something right here. Okay, let me see this. What the heck? Okay, so let's see what this is. On November 15th, 2023, Law and Lumber hosted plaintiff's expert Dr. Joe Corcoran on his YouTube live stream. Dr. Corcoran spoke about his view that the video of the then current CEO and then the interim CEO of Johns Hopkins Hospital should not have been excluded in the punitive damages phase, and that if it had not, you can ask juror number 1, that would have put another 0 on the punitive damages. In response, juror number 1 commented that it would have added 14 zeros. Let's see. What is this? Okay, hang on. This is what I'm looking for, I think. Yes. Okay. Okay, this is what I need to bring up. Now, this is going to be about the juror. Right? Let me just make sure here. I see something. Yes, this is okay. This is the other one. Hang on. Hang on. Let me pull this over. Okay, so let's see. No, let me go back here. Where did my thing go? Here we go. All right. So, defendant John Hopkins, by and through the undersigned counsel, hereby moves this court for an order permitting an interview of juror number 1, opening discovery into evidence of juror misconduct, requiring the preservation of certain evidence on an emergency basis and creating and granting a new trial on juror misconduct on the grounds set forth herein. According to the Florida Supreme Court, potentially harmful juror misconduct, including contact with a juror during trial about the pending matter, is presumptively prejudicial. A party seeking a juror interview does not have to conclusively establish that the alleged juror misconduct occurred and actually prejudiced his case. Okay, let's go here. This motion sets forth a reasonable basis for belief that juror number 1, the foreperson, engaged in presumptively prejudicial misconduct during the course of the trial by deliberately disregarding the court's specific instructions not to discuss the case with anyone during the trial, not to consider any evidence or information outside of what was presented during the trial, and not to form or express any opinion about the case prior to deliberations. This motion is supported by the sworn affidavit of Ethan R. Shapiro, Esquire, attached hereto is Exhibit A. The affidavit and evidence attached hereto is Exhibit B, discovered by defense counsel after the verdict, reveals potentially harmful and therefore presumptively prejudicial juror misconduct arising out of improper communications and contacts between juror number 1 and his wife, Mrs. Langle. Collectively, the Langles, who resided in the same household during the course of the 9-week trial, the evidence reveals a shocking level of involvement in the case and palpable bias in favor of the plaintiffs on the part of juror number 1's wife, Mrs. Langle, as well as social media posts sharing inside information Mrs. Langle could only have obtained from her husband. Considered in its totality, the evidence provides a reasonable basis for a belief that juror number 1 disregarded his juror oath and this court's instructions by engaging in improper juror communications and contacts. Juror number 1's own post-verdict involvement on social media corroborates defendants' belief that the Langles engaged in improper contact with communications regarding the case and formed a shared bias in plaintiff's favor as evidenced by the verdict. In addition to the presumptively prejudicial contacts and communications between juror number 1 and his wife, the evidence warrants a juror interview and a new trial for the added reason that juror number 1's wife's involvement on social media during the course of the trial has undisguised bias in favor of the plaintiffs, and her alignment with the social media influencers closely linked to the plaintiffs known as Jules, Jules, as the spouse of the jury foreman, undeniably compromises the integrity of the judicial system. Defendant therefore moves for an order permitting an interview of juror number 1 and his wife, Yolanda Langle, to establish the presumptively prejudicial contacts and communications described herein as grounds for defendant's entitlement to a new trial. Defendant additionally moves for an order permitting discovery of information establishing juror misconduct by juror number 1, as well as an order requiring juror number 1 and his wife to preserve evidence, including text messages, social media activity, and other electronic data pertinent to their communications and contacts with one another with other third parties regarding the case on an emergency basis to avoid spoliation of evidence. Post-trial research and information obtained regarding Mrs. Langle's social media history reveals that her personal engagement with the public commentary of this trial is unlike that of a member of the public who shares a general interest in the case. Okay, so they're saying, hold on, I've just got to get a drink because I've got to get something to. So what they're saying is that Mrs. Langle didn't just post like any of you who are interested in this case would post. This is different because they're going to say she had information that could only come from certain places, and one being her husband. I just want to get on so I can see you guys. Okay, there you are. Hope there you are. There you are. Okay. So it says, who shares a general interest in this case and is particularly inappropriate given her role as the wife of the jury foreman. Mrs. Langle's social media posts foreshadowed questions from juror number 1 to witnesses, shared information on the thought processes of the jury, and highlighted her heavy personal bias in favor of the plaintiffs and emotional investment in a verdict in their favor, a bias apparently shared by her husband, juror number 1. Let's see. Gia says, that's the number, confound. That's beyond crazy. Wait, what are you saying, Gary? I just found something. What'd you find, Gia? What'd you find, Gia? Hi, Gary. Okay. Let's look. Gia, if you found something, you can always send it to my email. Okay? That's great. I love people that find things. Okay, so here we got, so she foreshadowed the questions that he was going to ask, highlighted a heavy personal bias. The posts give rise to a reasonable belief and concern on the part of the defendant that the jury's verdict has been tainted and that defendant has been deprived of its right to a fair trial before an impartial jury. And now, if you remember, I told you guys about this right after the verdict, that this was going around, that these people were posting in the social media groups. Hi, please check the files. Okay, let's go through this one first, though. In addition to her post, Mrs. Langel's presence at trial cast further doubt on the integrity of the jury verdict, which was guided by her husband as the jury foreman. On October 30th, 2023, Mrs. Langel physically attended the trial proceedings in this case, where her husband was impaneled as juror number 1. Juror number 1 said nothing of her presence. You might remember, during closing arguments, there was something about juror number 1. Now, you remember that the defense asked to have juror number 1 removed. On November 2nd, they filed something. He wasn't removed. And then I told you, right after that, they came right there and, well, nothing that's public record would be confidential. If it's there, it's not confidential. If it's not redacted, it's not confidential. Okay. So then we have juror number 1 said nothing of her presence. Prior to her appearance, Mrs. Langel sought out Jules, who was demonstratively embedded with the plaintiffs and served as their public advocate, if not de facto agent, both at trial and subsequent to the verdict. Mrs. Langel and Jules exchanged personal phone numbers, and Mrs. Langel made plans in advance to meet Jules in the courtroom. On October 30th, 2023, Mrs. Langel can be seen in video footage in the courtroom for the entire day, often seated next to and speaking with Jules. For her part, Jules became notorious in the online communities that covered the trial because she not only physically attended each day of trial, but she also provided regular updates on her social media platforms such as TikTok and YouTube. Jules also shared her personal conversations with the Kowalski family, as well as her observations in the courtroom regarding the jury. It's apparent from these videos that Jules shares a close relationship with Jack and Maya, making her friendship with Mrs. Langel all the more inappropriate. For example, on October 9th, Jules posted a video on her TikTok page, stating that she gave Maya Kowalski her rosary beads prior to Maya's live testimony that day. On October 11th, Jules called into Recovery Addict YouTube live stream covering the trial. Stating that she texted with Maya over the weekend, and after giving her the rosary beads, she asked the plaintiff's counsel to not object to the jury's questions regarding whether Maya carried a rosary, because she knew Maya had the rosary beads in her pocket. This demonstrates that Jules was more than just a public observer of the trial, but an active participant and de facto agent for the plaintiffs. Jules even publicly shared photographs of herself with the plaintiff's experts and members of the plaintiff's trial team, and even appeared center stage in a photograph with the plaintiffs and their counsel after the verdict was read. In light of Jules' intimate relationship with and bias in favor of the plaintiffs, the development of an alignment, if not friendship, between Jules and juror number one's wife is alarming. Defendant was entitled to a trial before a fair and impartial jury. The fact that the jury foreman's wife, with whom he resided during the course of a 9-week trial, engaged in friendly discussions while in close proximity to the plaintiff's advocate, Jules, contributes to the defendant's reasonable belief that it has been denied its right to a fair trial. Defendant has obtained evidence demonstrating that Mrs. Langille was heavily engaged with the trial online, both before and after she physically appeared in court, posting comments about the case that are unequivocally and palpably pro-plaintiff. Operating under the YouTube username Hippo Lover, Mrs. Langille began posting information, insights, and opinions about the case as early as October 13, 2023, during live stream coverage of the trial on the Law and Lumber, Recovery Addict, and Lawyer You Know YouTube channels. Followed numerous journalists and vloggers covering this trial, including the producer of the Netflix documentary Take Care of Maya and the plaintiff's trial technology consultant. On a near daily basis, Mrs. Langille spent hours online, engaged in commentary about the trial proceeding, both in real time and after the trial day had ended and the jury was sent home, including her husband, juror number one, with whom she resided. These social media platforms transmitted commentary to audiences of thousands and exposed Mrs. Langille and brought into the Langilles' household information about the trial that juror number one should not have been aware of, as well as evidence not made available to the jury. In several instances, Mrs. Langille even donated money to these YouTube channels that offered both live coverage and reaction commentary of the trial to ensure that her comments would be spotlighted. To the thousands of individuals that tuned into those live stream broadcasts, You saw that she sent a super sticker, Gia? And Gary says this is mind-blowing. A lot of shady things going on during that trial. Wow. Okay. It strains credulity that to believe that the Langilles were not discussing this case in violation of the court's instructions. To the contrary, the evidence provides more than a reasonable basis to believe that the Langilles were exchanging information and belief regarding the case and about the defendant's predetermined culpability in violation of this court's instructions in Florida law. For example, during the live testimony of Detective Graham at the time when the detective was under cross-examination by the plaintiff's counsel, Mrs. Langille foreshadowed information she could have only learned from her husband, juror number one, when she posted the following comment. The juror Leo, law enforcement officer, will be asking questions. The day prior, Mrs. Langiel pretended a challenge by her husband, juror number 1, to Detective Graham when she posted Detective Grant, law enforcement officer junior, LOL, on November 8th, 2023. While the jury was deliberating, Mrs. Langiel paid to super chat the following comment. I think the note yesterday was frustrated that I think the note yesterday was frustrated jury that cannot reach money agreement and it will take days. Mrs. Langiel was apparently interpreting the juror's thoughts in relation to juror number 1's question. The day prior, regarding a request for a report by plaintiff's economist expert Christy Kirby, and she was right. Her comment contained inside information she could have only obtained from her husband, juror number 1. On October 31st, 2023, the day after the testimony of Catherine Beatty, Mrs. Langiel commented, they did not like Kathy Beatty or any of the witnesses. Defendant presented at trial the day prior. But how can Mrs. Langiel have known whether the jury liked Mrs. Beatty aside from information she obtained from her husband? And how could she have known that the jury did not like any of the other defense witnesses except from information communicated to her by juror number 1? Other comments and posts by Mrs. Langiel reflect that she was doing more than inappropriately engaging with the trial proceedings online. She was even monitoring the court's docket and reviewing court filings. For example, on October 18th, 2023, Mrs. Langiel commented, interesting motion, just on the case about DV yesterday. On the Sarasota County Clerk of Court, the DV motion by the defendants basically said that if the judge granted no appellate court on November 13th, 2023, regarding the joint commission issued this surfaced towards the end of the trial, Mrs. Langiel wrote, deposition today at 4 in Tampa regarding JC documents. Motion is in the court record filed by Mr. Anderson. In that vein, Mrs. Langiel also did Google research on the case as evidenced by her comment. There is a case on Google, Carol versus Carol, about the judge, Carol's mom, about the judge when he was 16. Judge Alterborn was the appeals judge. Super interesting. Mrs. Langiel found super interesting and post-worthy that defense counsel Chris Altenburn was involved years ago in an appeal involving the judge presiding over the trial, which demonstrates how deeply involved she became, not only in observing and commenting on the trial, but in researching about the trial and lawyers and even the judge. On October 27, 2023, Mrs. Langiel commented, I think Sally, SM, only relied on Tampa General Hospital to decide, discounted all others. Mrs. Langiel was advocating for the plaintiff's position and against the veracity of Dr. Sally Smith on a consequential issue in the case. Not coincidentally, in a proposed question dated October 12, 2023, juror number 1 questioned the court regarding the existence of probable cause of improper actions by or of Sally Smith in her assigned role at Johns Hopkins All Children's Hospital, as was she written up or coached. Similarly, on October 19th of 2023, while the jury was formulating questions related to the testimony of Johanna Klink, APRN, Mrs. Langiel wrote, they should ask if she, Nurse Klink, lied, LOL. Mrs. Langiel's post, as compared with juror number 1's questions, are additional evidence of improper contacts and communication between the Langiels, warranting both a juror interview and a new trial under Florida law. Through several of her comments and posts, Mrs. Langille also inappropriately expressed concern that the clock was running out for the plaintiffs to put on their case. For example, in 4 separate comments posted on October 17th, Mrs. Langille wrote, "Anderson is burning time. He won't have any left to defend. He needs to be careful on time. I think you're right. Depots to burn time and bring in witnesses that will burn Anderson so that he will use time. I wonder if they defense are getting their witnesses so Anderson runs out of time. Don't burn your hours, Anderson. Please, we need you." But why was Mrs. Langille of the opinion that plaintiffs were running out of time? If she wasn't discussing the case with her husband, and who was she referring to when she said, "I think you are right"? Her bias in her role as the jury foreperson's wife with whom he was living during the 9-week trial is undeniable and palpable and creates more than a reasonable basis to believe what defendants suspected when they filed their motion to disqualify, that juror number 1 shared the same bias. Hi, Scooters McBooters. Hey, I heard about you, Scooters McBooters. You have, what do you have? You have a subreddit or something? I'm happy you're here. Welcome. I'd love to have you call in sometime if you want to call in. Anyway, let's see this. Okay. So where were we? Mrs. Langille also somehow knew or believed that the jury was asking questions that were purportedly serving to save plaintiff's time on the shot clock. For example, on October 19th, Mrs. Langille wrote, "Maybe Anderson will cross after questions to save time." On October 19th, she posted, "So proud of Anderson. He was like a cat. No questions after, just to pounce after the jury questions. Kudos." On October 20th, Mrs. Langille paid to super chat the following comment: "If plaintiff runs out of time, can the depositions be played since part goes to plaintiff's time?" On October 25th, Mrs. Langille commented, "Yes, more hours for the plaintiff." In response to continued questions from jurors on October 19th, Mrs. Langille commented, "Jury, love it." Even if evidence of a shared alignment between juror number 1 and his wife as to the desired outcome of the trial were not so compelling, and it is, defendant would still satisfy the standard for a juror interview. Specifically, the entire internet community was made aware of the heavy bias in the plaintiff's favor on the part of a juror's wife, plainly compromising the integrity of the jury process, as will be shown. Even an appearance of impropriety warrants a new trial as a matter of public policy under Florida law. Okay, let's see. Hi, Julie. This is so crazy, right? Yeah. As his wife and household companion during the course of the 9-week trial, Mrs. Langille was serving as juror number 1's agent to the internet world. Mrs. Langille has compromised the public's confidence in the integrity of the jury system through her biased posts and improper emotional investment in a verdict in the plaintiff's favor, given her role as juror number 1's spouse. Her actions also brought information into the Langille's household that this court prohibited the jurors from reviewing. Do you appreciate it? Yeah, thank you. I've just... Hold on. Let me finish this this drink here so I can just not be interrupted. Just give me a second. Just... I'm sorry, that was like an icy kind of a thing that I had, and I couldn't keep. I just had to finish it, so I didn't want to bother you. But now I'm good because there's a lot of reading. Okay. So let's see now. Let's just not get an ice cream headache now that I just downed that thing. Her actions also brought information into the Langille's household this court prohibited jurors from reviewing. On November 6th, 3 days before the verdict, right? The court heard the defendant's motion to disqualify juror number 1, which, and we just went over that before, right? Which was premised on juror number 1's suspected bias and prejudice in favor of the plaintiffs. Plaintiff's counsel, Mr. Anderson, changed his position several times throughout the course of oral argument on the defendant's motion. Upon being pressed for a response by the court, Mr. Anderson replied, "I changed my mind. I'll go with juror number 106, so I'll agree with you." The court then pressed again, and Mr. Anderson responded, "I think I'm going to go with that." Then, as the court was outlining the agreement of the parties and identifying which alternate would take juror number 1's place, Mr. Anderson abruptly announced, "You know who I didn't check with throughout this whole thing? My client." After about 15 seconds, Mr. Anderson changed his position yet again and announced, "I'm going to go with my client. I have to switch positions because my client feels more comfortable with juror number 1. So I'm going to switch positions based on my client's input." In response, Mr. Kowalski, who advocated to keep juror number 1 on the jury, can be seen turning to Jules and nodding his head with a smile. Wow. This exchange is further evidence of an alignment between the plaintiffs and Jules to insulate a verdict in plaintiff's favor by retaining juror number 1, who along with his wife was heavily biased in the plaintiff's favor. What defendant suspected before the verdict, based on juror number 1 questions, a bias in favor of plaintiffs warranting his removal as a juror and replacement with an alternative was demonstrated beyond just a reasonable belief after the verdict? Specifically, Mrs. Langille was not the member of the husband and wife pair to engage in public internet posts regarding the case. Following the verdict, juror number 1 joined his wife on, remember I told you this, right away, joined his wife on these public platforms by immediately posting to the, I hit my mic, the Take Care of Maya Facebook group, a plaintiff-favored internet community hotly opposed to any commentary favoring the defense, created in response to the calculated and sensationalized Take Care of Maya Netflix series. Juror number 1 quickly posted, "Oh, now that is too funny, too cool," to an AI-generated image of Judge Carroll in battle gear standing in front of a smoking picture of a Johns Hopkins All Children's Hospital building with the caption, "I went and got the IJ documents myself." The impropriety of an image of the judge presiding over this highly publicized trial, condemning the defense, coupled with the jury foreperson's undisguised delight in the image, additional evidence of juror impropriety and misconduct. On November 10th, 2023, the day after the verdict was announced, Mrs. Langille posted a photo of juror number 1 on the Take Care of Maya Facebook group, thanking everyone who stuck up for juror number 1. Presumably referring to the defendant's motion to disqualify juror number 1. The same day, juror number 1 posted the following comment in response. "While the other jurors were escorted down to be transported, I was asked to remain by the SCSO lieutenant. Oh boy, I'm in trouble once again." But it was for just some security talk about that. Oops. Juror number 1's comment about being in trouble once again indicates that he knew prior to being released from the courthouse the defendant had moved to dismiss him as a juror, a fact he should not have known about if he was abiding by this court's explicit instructions to not discuss this case with anyone or do any research on the case. The fact that juror number 1 was exposed to information relating to the defendant's motion to remove him as a juror in violation of this court's instructions is further evidenced by Mrs. Lingeal's post thanking the pro-plaintiff Facebook group who stuck up for her husband. Juror number 1 continued to post in this plaintiff's favored Facebook group, which hailed him as a hero for being responsible for the verdict against the defendant's hospital, while juror number 1 made sure to repeatedly express that it was not solely his decision. He seemed to enjoy his newfound notoriety among these online platforms by engaging in posts and videos celebrating him as a hero. To date, juror number 1 continues to post about the case, even to the point of advising the internet community regarding filings that will be being made Wednesday, November 22nd. The internet community, in turn, has suggested that juror number 1 remain humble and quiet out of respect for the process. But as defendant has shown by reference to evidence, juror number 1 apparently has no respect for the judicial process or for the defendant's right to a fair trial before an impartial jury. If interviewed, defendant expects juror number 1 to respond with a self-serving denial of any communications with his wife about the trial. But on Facebook, juror number 1 loved a comment by a user praising the fact that his whole family was able to come to court and observe the trial. In another comment, when a user pointed out that juror number 1's wife being in the audience could be a problem for the verdict, juror number 1 laughed at the comment to mock it. Juror number 1 also liked a comment from the group which advised him to be careful regarding what questions he asked, as a new trial could be granted if he says something now that implies he made up his mind. These posts demonstrate that juror number 1's bias, which served as the basis for the defendant's motion to disqualify juror number 1, was apparent to the plaintiff's favored online communities that supported juror number 1. Why else would juror number 1 need to be careful if he had remained impartial throughout the trial? And why did these users worry about juror number 1's wife being in the audience? On November 11th, juror number 1 also joined the Law and Lumber YouTube live stream, paid the host, known as Rob, $100 and commented that he would be happy to discuss the case with him. Rob, a lawyer himself, appreciating the appearance of impropriety arising out of juror number 1's communications, advised juror number 1 to first consult with the plaintiff's counsel before speaking publicly. Juror number 1 paid Rob $2 in return for the advice, commenting, "Agreed." Juror number 1 later removed several of his comments from the Facebook group, evidence that he too realized the appearance of the appearance of impropriety arising out of juror number 1's communications, advised juror number 1 to first. Okay, hold on a minute. Where was I? Juror number 1 later removed several of his comments from the Facebook group, evidence that he too realized the appearance of the impropriety of his actions were demonstrating to the internet community, and therefore that his conduct was necessarily undermining public confidence in the integrity of the jury system. On November 19, 2023, shortly before filing this motion, juror number 1 admitted to the Take Care of Maya Facebook group that he had contacted the plaintiff's counsel, who advised him that this very motion would be filed. Believed by this Wednesday, defense has to have something filed. Then Judge C has to actually make some reviews and rulings before actually hitting the gavel and closing his phase of the case. So, we're listening to counsel as it ain't over yet. On November 15, 2023, Law and Lumber hosted plaintiff's expert Dr. Joe Corcoran on his YouTube live stream. Dr. Corcoran spoke about his view that the video of the then current CEO and the interim CEO of Johns Hopkins All Children's Hospital should not have been excluded in the punitive damages phases, and that if it had not, you can ask juror number 1, that would have put another 0 on the punitive damages. In response, juror number 1 commented that it would have added 14 zeros. In addition to the above improper contacts and communications, defendant has a reasonable basis to believe that juror number 1 also inappropriately conducted internet research regarding one or more issues, in this case in violation of the court's order to not consider information. Outside of the evidence presented at trial. On October 9th, 2023, juror number 1 posed the following question to Maya Kowalowski. When it comes to creature comforts, were you made to feel comfortable, or were you made to, or just felt that you were in a hostile place? The phrase creature comfort was not used by any witness at trial, but it is used on Dr. Kirkpatrick's RSD Foundation website related to ketamine treatment as demonstrated below. Okay, so here it says, treatments are performed with a 4-day high-dose ketamine infusion on our outpatient basis on the Foundation Surgery Center. For information on our research on the ketamine coma procedure, please visit our research section. The key to success is to get the dose of ketamine as high as possible and hold the dose up as long as possible with safety and creature comfort as primary concern. Measuring clinical outcome on an objective basis is also critical to success. Creature comfort. Moreover, in videos on his website depicting his treatment of other females of similar age as Maya, Dr. Kirkpatrick often uses the phrase creature comforts when speaking to patients about the circumstances under which ketamine treatment is the most effective. It is defendant's reasonable belief, based on the foregoing, that juror number 1 visited Dr. Kirkpatrick's website to research issues in this case, including with respect to diagnosis and treatment of CRPS in violation of this court's order. Finally, it appears, based on a public search of the Sarasota County Court document, that Deborah Salisbury was involved in Mrs. Langell's 2007 domestic relations proceeding, a fact never disclosed on juror number 1's jury questionnaire during voir dire. Exhibit C, juror number 1's prospective juror questionnaire. Similarly, juror number 1 denied viewing the Netflix documentary related to this case, Take Care of Maya, on his supplemental juror questionnaire, and denied having any conversations or overhearing any conversations concerning this movie. This seems unlikely given Mrs. Langell's heavy engagement, investment, and close monitoring of the case, the court docket, and her following of social media of the movie producers for the documentary. Juror number 1's post-trial post to the Take Care of Maya Facebook page group further undermined his feigned ignorance of the documentary. Evidence of juror misconduct on the part of juror number 1, both individually and arising out of his wife's involvement in this case, social media posts, and obvious bias in favor of the plaintiffs, is substantial, presumptively prejudicial, and compromises the integrity of the verdict, the jury system, and the judicial process as a whole. The evidence gives rise to a reasonable belief that juror number 1 impermissibly obtained and shared information about the case during the course of the trial with and through his wife, as well as plaintiff's advocate, Jules, in violation of this court's instructions and the requirements of Florida law, and because the evidence provides a reasonable basis for an inquiry. Defendant moves for an interview of juror number 1 in support of its motion for a new trial, and at the court's discretion for an interview of juror number 1's wife, Yolanda Langell, In addition, defendant further requests limited discovery into the issue of juror number 1 in support of its motion for a new trial and at the court's discretion for an interview of juror number 1's wife, Yolanda Langle. In addition, defendant further requests limited discovery into the issue of juror misconduct in anticipation of this interview, as well as the emergency order requiring juror number 1 and his wife to preserve text messages, social media activity, and other electronic data evidencing communications regarding the trial. Legal standard. In support of a motion for a new trial, Florida Rule of Civil Procedure permits a party to move for a juror interview if the party believes that grounds for a legal challenge to a verdict may exist. An interview of a juror is proper when there is a reasonable basis to believe that a prejudicial act occurred supporting a legal basis for a new trial, such as improper contact with a juror or misconduct of a juror. A party moving for a juror interview does not have to conclusively establish that the alleged incident occurred and actually prejudiced his case. Instead, it is only necessary to establish a basis for an inquiry. It contrasts to what is needed to prove entitlement to a new trial. A party seeking only a juror interview must set forth sworn factual allegations that, if true, would require a trial court to order a new trial. In this regard, a party should be allowed the opportunity to prove that he is entitled to a juror interview. Contact with a juror during trial about the pending matter, as defendant believes occurs in this case, constitutes presumptively prejudicial juror misconduct. Once an improper contact has been established, the burden then shifts to the party seeking to preserve the jury's verdict to demonstrate that the conduct was harmless. In this regard, once improper contact or juror misconduct is established by juror interview, the moving party is then entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. A juror who is biased or prejudiced is not fair-minded and impartial as required to prevent impairment of the right to a jury trial. The importance of an impartial jury is so fundamental that it is initially scrutinized at the inception of trial on juror challenges for cause. If there is a basis for any reasonable doubt as to any juror's possession of the state of mind which will enable him to render an impartial verdict, he should be excused Evidence of juror misconduct is also evaluated after a jury is seated. Specifically, it is within the trial court's discretion to grant a new trial which it is later suspected that the jury has been tainted, based on the basic premise that parties are entitled to a fair trial. Okay. Fourth District determined that the juror's conversations with his brother, this isn't a case they're discussing. Okay, let's see. Let's get back over here. Defendant submits that it, too, is entitled to a new trial as a matter of public policy based on the undeniable appearance of the impropriety arising out of the actions and conduct of juror number 1 and his wife. In this regard, defendant believes that a jury interview will shed additional light on the misconduct demonstrated by this motion and accompanying affidavit. And even if the misconduct is denied, as defendant predicts, neither juror number 1 nor his wife can erase the appearance of impropriety shown by their actions and social media posts. The appearance of impropriety, in turn, presents an independent basis for a new trial. Defendant submits that it has satisfied the standard for obtaining a juror interview based on juror number 1's suspected contacts and communications with his wife regarding this case, presumed receipt of information from outside influencers, and apparent internet research during the trial. Let's see. A snook-seeking juror interview does not have to conclusively establish misconduct occurred, but only of a basis for an inquiry. Evidence of juror number 1's suspected bias in favor of plaintiffs, more specifically set forth in defendant's motion to disqualify juror, has been compounded and confirmed by unsolicited evidence discovered post-trial involving the heavy social media participation in the trial on the part of the juror number 1's wife and presumptive agent Mrs. Langle, as well as Mrs. Langle's presence at the trial, and friendly communications with the plaintiff's advocate Jules. It has also been confirmed by juror number 1's own social media participation post-trial, which even the internet community has recognized as indicative of jury taint and misconduct. As noted, Mrs. Langle's social media posts include information she could only have obtained from her husband, juror number 1. The evidence, therefore, provides a reasonable basis for the defendant to believe that the juror number 1 communicated with his wife during the trial regarding the case in violation of this court's instructions. Such communications, in turn, constitute presumptive prejudicial misconduct under Florida law. Contact with a juror during a trial about the pending matter falls under the category of potentially harmful and presumptively prejudicial misconduct. The record evidence incorporated herein demonstrates that potential prejudicial communications between juror number 1 and his wife occurred during the course of the 9-week trial. Defendant does not have to conclusively establish that the misconduct occurred and actually prejudiced its case, but only a basis for an inquiry. Defendant has satisfied its burden by supporting its motion for an interview with allegations of juror misconduct. Okay, then they're talking about this other case. Let's see. Defendant believes it will establish improper contact and communication between juror number 1 and his wife during the trial, or other jury misconduct such as improper internet research by juror interview. If so, the defendant will be entitled to a new trial as a matter of law unless the plaintiffs can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. In the face of substantial evidence of presumptively prejudicial juror misconduct, culminating in an exorbitant verdict awarding plaintiffs every dollar requested on every count of their complaint, which itself should shock the court's judicial conscience, defendant submits that it would be impossible for the plaintiffs to satisfy the burden of demonstrating no reasonable possibility that the jury misconduct affected the verdict. Not surprisingly, defendant has not located a reported discussion revealing the extent of social media participation and blatant bias exhibited in this case. The 5th District has noted that jurors who tweet, blog, and surf continue to derail lengthy trials, resulting in mistrials and unnecessary waste of public and private resources. But this motion does not involve a mere instance of tweeting and blogging or alleged juror misconduct arising from the use of social media during a trial. Rather, the evidence presented reveals a shocking and pervasive use of social media by the spouse of a jury foreperson with whom the juror resided during the course of a 9-week trial, accompanied by a highly improper and pervasive bias in the plaintiff's favor. The evidence also reveals juror number 1's participation in the same social media activity post-trial, demonstrating a shared bias in plaintiff's favor on the part of the Langill, oh gosh, the Langills. Mrs. Langill, as juror number 1's wife, should have displayed an extra level of respect for the judicial process, if only to avoid any appearance of how many pages is this? There's a lot more. I might have to break this into 2 parts, or I need a small break. Let me see what you guys are saying so I can take a small break. Okay, let's see. I don't think that was mentioned in the trial. They say that they will get it in the end. Let me say how much they will get in the end. Does anyone know how long juror number 1 was a police officer and how old he is? I can try to find out. I think he was playing it up for the audience. The streams, his wife were watching through his questions. Probably. What's your sign? Hi, welcome. Let me see. What's your sign? Do you know why he got fired? Oh, 9 years and he got fired. How do you know that? Where'd you find that? Yeah, I saw it. Okay. Oh, okay. I'll check it out. Let me see. Let me see if I can see it in there. Hang on. Let me check. I need a little break. Okay. Oh boy. Okay, let me see. I can't look up anything anymore right now. I need a little break here. This is very interesting. Yeah, you're searching it right now. Okay, thank you. I don't know if that's true. Paint it black. Where are you? I hope you're okay. Seen you in a while. Oh my gosh. Crazy, isn't it? But you know what? The lawyers just are like, oh, did it really change the outcome? Oh, did it really do this? Okay, let's see. Oh my goodness. So you guys, what do you there's a lot of A lot of stuff with this trial. This trial was so long and just so tedious and well, I plan to continue this reading tomorrow because there's so many pages left. And Gary says there is some shady stuff that happened. And I'd like to know if any of you want to call in and do you like, you don't have to tonight, it could be tomorrow night or whatever. Would you like to discuss on panel? You don't have to go on camera if you don't want to. But would any of you consider discussing this on a panel? This is proven to be the case. If this is proven to be true, can jury number 1 be charged with anything? Let me see. He may be cited for contempt. Juror misconduct is when the law of the court is violated by a member of the jury while a court case is in progression or after it's reached a verdict. Misconduct can take several forms. Communication by the jury with those outside of the trial court case. Those on the outside include witnesses, attorneys, bailiffs, or judges. When the jury member brings outside evidence that they may have found themselves into the trial which has not been allowed by the judges or the lawyers and is used to create bias on part of the juror, the new information may be used to influence the final decision or conducting experiments regarding theories of the case outside the court's presence. Oh my goodness. Yeah, I don't know. Let's see here. So you have to see if you'd want to come on. Hold on a second. I have to get something. I have to get myself up here. It's crazy. Well, I do have to go for a procedure on tomorrow is going to be the last day that I can. What's tomorrow? 4th? Yeah, tomorrow's the last day I can eat. I actually can eat until Friday, until Thursday after noon. So I have to be on a clear liquid diet all Wednesday. Did they say in the motion that this Jules person knew Maya? Yes. That's what they say. I don't know who she is, this Jules person. Unless there was someone once when the Jen Stokes autopsy photos were sold by 2 YouTubers. And she called them out with somebody else. If that's that one, I don't know. Because that's a common YouTuber name. I don't know if it's the same person. But I don't know her well. I just saw her that one time. That's it. I don't know her at all well. At all. But it's nice to have you guys here. Did you come from the Reddit group? Did they? Okay. Be nice to talk a little bit. But what do you guys think about the verdict? Are you and I'll go over that. Like I said, I will. I will go over the rest of that. So I will. But what did you guys think of the verdict? Do you guys think that Gia and Gary and who is the, what is your sign? Do you think that Maya was, now there's people saying that Maya might have Munchausen's herself, they're saying, or that she was creating the symptoms in order to get attention from her mother, things like that. Do you guys think that's true? Do you guys think that's true? Do you guys think that's true? Do you? I've been here before a couple of times. Oh, you have, Gary? Well, thanks for coming. I think the amount of money awarded was nauseating. Yeah, I do too. I think it was crazy. You know, it really was. It was absolutely crazy. And you know what? This kind of brings up a lot of things, right? Because if, you know, you have like all kinds of conflicts of interest, right? Because if, let's say, Jules is really close with Maya's family, and then she's really close with juror number one's wife, and then juror number one's wife is talking to the juror number one. I mean, yes, what about, hey, you guys award us this, and we'll, how do we know? How do we know? Tell me how we know there wasn't something that was related from juror, from this wife, and I'm just saying, okay, this is just something I'm saying, like, can you prove something like this didn't happen? That the wife said, you know, talked to the juror number one, and then she was the liaison between the family and whatever, Jules or whatever, and said, if you get us this verdict, the family is going to give each juror $500,000. Can you prove that that wasn't the incentive, that there wasn't an incentive of that? Do you know what I mean? Maybe they awarded such high damages because they're going to spread it around. How do we know it's all not a big something going on with all of them? That's what I mean, right? With all of them. With that much awarded, right? Because that much awarded is crazy amount. They already have 2.5 million, and now you're talking about what, $260 million? Well, I mean, 12 million. What if they wanted to give them all 1 million? I'm not saying that they did. I'm saying that it's possible, right? If there is this, all of this connected. That's where my mind is going. But I toss a lot of stuff like that around during cases. Yeah, I like this discussion. We have one like these all the time on Discord. Oh, do you? Yeah, I don't go on Discord, but so they awarded for sure based on my assumptions. Then can you hear my flying squirrel? Can you hear my flying squirrel squeaking? I'll be right there, Rocky. Rocky wants me to bring, I always bring Rocky. Rocky's nocturnal, so he just got up and he's got his food in there, but I always bring him a little treat, either like dried pineapple or sometimes I give him a lemon cookie that he likes and dried strawberry. So he's probably wants his little treat. Crazy. Yeah, I don't know. Speechless. Yeah. Would they have juror number 1 and Jules thinking they were getting a pay cut like the next day? Yeah, well, I don't think they were going to think you can get it the next day, but you know, I don't know. Right? I don't know. Stranger things have happened. More crazy things have happened. You will have to watch chat. Gia and Kevin had a big discussion going on. Did they? I'll have to look back. I'll have to look back for sure, for sure. So, but we'll have to see. I mean, if anybody would like to call in, all you have to do is tell me. We're on Zoom. I'm getting like exhausted. I don't know why I'm so tired. I am. I've been staying up way too late and I've got to kind of like bring it down a little bit. So I think tomorrow night we will if the one thing that still has this, what still has what? This banana puzzled, how this came full circle. It will come out eventually. How it came full circle. A lot of things with the players of this trial. Something that doesn't sit right with me is something about her taking her life, them not finding her till the next day, right? They didn't find her till the next day. And what about the IV? The 911 call. Did any of you think the 911 call, he really didn't sound that concerned? I don't know. I mean, I know, yeah, grief will put you in a state of numbness where maybe you can talk very matter-of-factly, and that can happen. It can. I know that. But it just seemed like so shy. I don't know. It just seemed strange to me. The 911 call seemed strange to me. Just something seemed strange to me, the 911 call. The whole thing seems sussy. Yeah, and I don't know. And how angry Maya got when those pictures of her at the homecoming and at Halloween surfaced, right? She got very, very, very angry. But I hope that you'll come and discuss tomorrow. I think we'll finish the reading of this tomorrow. I know that Let's see what happened in the regular. I haven't seen regular news or anything. It's just been so crazy. Crazy. Hold on. And I've got to go, like I said, for that procedure. So I have to make sure I have everything I need tomorrow. Let me see. What am I looking up? Oh yeah, any thoughts on the day? Movie extra charged with killing Hollywood consultant because he was friends with the director that she was stalking. What? My head can't take that today. 5 dead, including a suspect and 2 children in LaQueen stabbing. That's crazy. Woman left for dead in Texas pasture, beaten, throat slash, rolled up in plastic. This is horrendous, isn't it? Family of teen kidnapped by catfishing deputy. Sues sheriff's office, destroyed our family. 1 dead, 4 injured after a homeless man shot in Las Vegas like a war zone. Husband guns down wife, childhood friend, and drives 170 miles to take his own life. What? That people need problem-solving skills. It's like murder is not the answer. And gosh, I think we need to put that somewhere on a shirt, okay? Murder is not the answer to your problem. Yeah. So what we do here to unwind before we go is we just play a daily word puzzle. Okay, it's how it's kind of like it gets us relaxed. So if you're wondering what we do, yeah, we play it's a daily word game. You can play along, but we play a daily word puzzle. You can talk, you can still talk. Hi, Janine. How are you? Yes, it's the Scooter McBooters. Do you know Scooter McBooters? Which doctor suggested the wheelchair assistance? I don't know, but I have a lot of questions. And you know, I was going down a big rabbit hole, and I was watching her bed dancing. And, this case reminds a movie called Run. Kevin, write that down, a movie called Run. What's that about, Gia? What's the movie called Run about? What's the movie called Run about? Tell me. What is the movie called Run about? What is it? I didn't think there could be another. A few of us. Hi, Janine. Hi, everybody. Does anybody want to call in? You can call in and talk. Do you want to call in and talk? If anybody wants to call in, come on. You can call in. Absolutely. It's about a controlling mother. It's called Run. Oh my gosh. When was that made? I'm going to look at it. Hold on a minute. Run movie. It's a 2020. I didn't hear about this American film. I've never heard about this. Is it on Netflix? How come I've never heard this? I want to go watch it. Maybe we'll go watch it after this. We have a movie club. You can come and watch a movie with us. Want to come and watch a movie with us? Okay, we watch it together on Zoom. Run, referred to on screen as Run, is a 2020 American psychological horror thriller film directed by Anish. Oh gosh, Anish used to love me. He came in here all the time asking me to marry him. I'm not joking. True story. Chiganti, and written by, but I don't know if it was Anish Chiganti. It was Anish, what was his name? And written by Chiganti and Sev Ohanayan. The film stars Kiara Ellen as a disabled teenager, Chloe Sherman, who begins to suspect that her mother, Diane Sarah Paulson, has been keeping a dark secret about her upbringing. The film has connections to other films by Shigante and Obhayan, and it's the second installment of the filmmaking duo's Searching Film series. Run was released in the United States via streaming on November 20th, 2020 on Hulu. Why have Hulu? Is it still there? And was released in other territories, both theatrically and through streaming, by Lionsgate International and by Netflix. The film received generally positive reviews. So Diane Sherman gives birth to a premature daughter whom she goes to see lying in an incubator surrounded by the hospital staff, and years later Diane lives a quiet life with her now teenage daughter Chloe. Due to circumstances of Chloe's birth, she suffers from arrhythmia, hemochromatosis, asthma, and diabetes, as well as paralysis at her legs. She uses a wheelchair, she takes multiple medications, and is homeschooled by her mother. One morning, while looking through a bag of groceries for chocolate, Chloe finds a prescription bottle of green pills with Diane's name on the label. However, Chloe later inspects the bottle. She finds a label bearing her name has been pasted over the original. Chloe tries to look up the name of the pills, Trigoxin, but discovers the house has no internet connection. Diane is seen sitting in the dark behind her next to an unplugged router. The next day, Chloe dials a random number from her mother's bedroom phone and asks the answering stranger to look up the drug. He tells her it's a heart medication and that all pictures of the medication show a small red pill. Chloe asks Diane to take her to the movies. During the film, while pretending to go to the bathroom, she rushes to the pharmacist safe across the street from the theater. The pharmacist at the desk reveals the green pills are a relaxant called Ridocaine, which has only been approved for dogs. When Chloe asks what would happen if a human took it, the pharmacist informs her that it could paralyze the legs. Upon realizing her mother may be giving her the pills to impair her ability to walk, Chloe begins to hyperventilate. Diane rushes in and sedates her daughter to take her home. Chloe wakes up in bed and finds her bedroom door locked. I won't give out the whole thing, but that's what that's about, huh? Sounds pretty good. I don't want to give it out. It's not on Netflix. Is it on Hulu? If you want to listen... Oh, now I know, yes, nobody should believe me. Yes, I've heard about that. I have. Thank you, Gia. I heard about that. Oh, I know, Janine. Everybody, I can get a lot of like hate in the comments about like, how dare you? What is wrong with you? Why would you say that this could be this? And I try to do it. I just say there's things I don't understand. Like, it was 87 days, okay? 87 days. And it just seems like, why wasn't she like more resolved? Like, if you give her the aggressive nature, like, why would you stop fighting? Why would you just give up? And people go, because the judge said she couldn't hug her. But that would make a mother dig your heels in. I don't want to, and say, what do you mean? I'm going to fight for my child. I'm going to fight like crazy. And yeah, you might be dejected, but then you're going to get up and say, you know, I'm not going to do this. I'm going to fight. I don't know. That's what I just think. I mean, it's just something just seems so odd. So odd. It's probably on Hulu. Okay, I have Hulu. I have Hulu too. I have Hulu. The Run trailer's on Hulu. Okay, so it probably is there. Okay. Great. Great. Yeah, and we're fine with people that don't have the same outlook. And nobody has to get like nasty or like somebody feels like that. Just calm down, you know? You don't have to get so freaked out. I don't mind if someone, you know, has a different outlook. That's fine. You know, that's just fine. But like, we're not allowed to question anything. Like, you know what I mean? It's like, I don't know. It's very strange, right? But we'll, I mean, yeah, tell your friends about us. Tell your friends about us. And we're going to go into the rest of that tomorrow night. If you want to come on panel tomorrow night. Kevin, what is with this word game? I'm going to have to do it in the morning, I think. I already got math. There you are, Margot. Come on, everybody's. What do we do here? Yeah, it'll be fun to discuss it tomorrow. If you want to come on, I'll finish reading that. Oh, yeah, they were horrible to each other. Yeah, if you didn't feel the way they did, they were like screaming at you that you're just like, horrible. What's wrong with you? How could, you know, it's like, well, there's other, I don't know. Oh, it's really bad. Hopefully you can come on and join us tomorrow. Oh, good, good. Come on. Are you subscribed? Make sure you're subscribed. You hit the bell so you get notified of when we put our live up, which should probably, you know, be tomorrow night, God willing, you know. And Kevin, I need the words. I can't think anymore. Margot, where are you? Find something. She said her channel has been getting so many words. What do you mean? The one that was, you mean the one that from the one that's in the court papers with the J? Really? What is she getting reported for? What? I don't watch her channel. Is she saying what's going on? What did Kevin? Massive? But it has a cupcake sticker on her video. Okay, I don't know which one that is. What I don't know what, I don't know. Hi, Holly. How are you? How are you doing? How's it going? Oh, Micah? Okay, one more and then I can go to bed. I'm doing well, and you? I'm doing okay. I'm just really tired, Holly, and tomorrow's the last day that I can eat before my procedure. So, that means I'm going to have to go out and get my stuff because I have my procedure on the 6th, which I'm nervous about, but not that nervous about. I'm just going to let myself say I'm going to go for a nice sleep and just try to be relaxed about it. Okay, I'm feeling a little bit more relaxed about it, and I'm just going to relax. Hopefully. I hope I just don't have like a whatever. But it's just I'm going to a different place, but it'll be okay. I know it'll be okay. Like Jimmy will always say, when's your procedure? Well, by such and such a time, you know it'll be over. All right, one way or the other, it'll be over. Thanks to you, and thank you, Holly. So I'm gonna go get us some rest, and then tomorrow night I'm gonna be on, and I'm gonna finish the second half of that document there. So I hope that you guys come on, and then maybe we'll open up the panel and you guys will call in or something. But make sure you guys come tomorrow night so we can all discuss. Yeah, absolutely. Please mark it on your calendars. No, but just make sure you're subscribed, and then it'll give you a note. Hit all notifications, and you can get a notification. Miss. Okay, is that? I thought I did miss. No. Okay. Yay! We're done. We're done. We're done. Okay. Well, you guys, thank you so much for coming, and it was really nice. I appreciate it very much. Make sure, yeah, I know. I have to be on a clear liquid diet. So anyway, see you guys. And please tell your friends that we don't bite. Tell your friends that want to discuss it. Come on in. Come on. All right? Love you guys. God bless. Prayers. See you tomorrow. Be well. Be kind. See you later.